a state judge in Tennessee and two commissioners are insisting that I didn't exhaust my administrative remedies, and therefore my case, State ex rel. David Jonathan Tulis versus David Garagano et al., be dismissed. I'm appealing the dismissal in Chancery Court in Davidson County in the Nashville area in the Tennessee Court of Appeals, my brief having gone in yesterday explaining why I do have a right to sue these two commissioners for fraud and for ultra-virus acts, that is to say, acts outside the scope of the statute, and acts arbitrary and capricious. In other words, fraud is a nuisance not protectable under sovereign immunity and not bound by the rules that require exhaustion of administrative remedies. I'm the investigative journalist in Tennessee who's proposing what is a novel and new and unusual theory, making the argument in the Sixth Circuit Federal Court of Appeals. But the idea is one that has been thrown at me more than once. And so I'm saying let's throw this idea at the cops, at the county prosecutor, at the district attorneys in traffic cases. I'm the journalist who covers traffic cases as if they're a big deal. You may have on one floor of the courts building a murder trial going on in one courtroom and traffic court down at the other end. Well, I cover the traffic cases because there we have the continual harassment, the continual bombardment, if you will, the leveling of liberty by routine, enhancing the police industrial complex, the judicial police industrial complex, and churning out convictions and plea bargains, injuring the poor and affecting minorities and those the scriptures tell us we have to be most concerned about. The injustice done against the alien and the stranger, the weak and the poor, the orphan and the widow, repeatedly in the prophets, are those people for whom Christians should be most concerned about when they are abused by rejection of due process, rejection of the procedures that bring a criminal case into existence. So I cover traffic. I don't cover murder. I don't cover rapes, but I cover the routinization of harm and indifference to the law itself. My theory that I have been discussing here is the exhaustion of administrative remedies theory to end your particular traffic case. If you go to my Substack, you can see articles about this, but there are four main points of law usable in every state that I suggest in my theory that we can use to end traffic stops entirely as a program in our states and also defeat criminal charges against us. And the four elements are privilege. In every state, driving and operating a motor vehicle constitute a privilege. That means a special grant or favor upon an economic occupation. Privileges are occupations or trades or callings that are controlled and owned by the state. So number one in my theory is privilege. Number two is the commissioner authority. Commissioner authority refers to the commissioner who issued the license that allows you to participate in the privilege taxable activity. Again, the key phrase, privilege taxable activity, that is driving and operating a motor vehicle. So the commissioner is the place where traffic cases are to be heard, not in criminal court. Number three is the UAPA, Uniform Administrative Procedures Act. Every state has one because every state is an administrative corporate body, and the bureaucracies in the executive branch run in terms of the UAPA, which is due process in agency. So number three in my theory is UAPA. Your state has one. And number four is the exhaustion of administrative remedies doctrine, which is a universal doctrine in all the states. There's a federal doctrine, and it coheres this way. The moving party, the state, in a matter pertaining to a license, must address the licensee and prosecute its claims against the licensee. Where? Not in criminal court, but in agency, in the department, in the DMV, okay? Your criminal case is improperly being prosecuted criminally. It's premature. It's unripe for prosecution. It must be heard where? Under the commissioner, under the DMV head. That's the party who's supposed to hear the case. It's not right, criminal, no. And so the defense is there's no subject matter jurisdiction. The case must be heard in agency under UAPA in terms of the exhaustion theory.